Okay, welcome everybody. I just welcome you on behalf of the Institute for European Policy Making, and then I will give the floor to the speakers. Just a few words about our institute.
Okay.
Okay, Leonardo, I'm just introducing the event and the Institute for European Policy Making. It's a pretty brand new venture for Bocconi University. The YEP, as we call it, is a think tank in one of the most important university in Italy and in Europe, which is Bocconi. And the idea is to join to create a bridge between academic research and the policy debate. The idea came to Mario Monti when he stepped down as president of Bocconi University. He decided to launch this think tank as a legacy of his experience and his approach to policy, which is rooted in the rigor of academic research, but very, very keen to be relevant in the policy debate. So now we have this think tank. Our director is Daniel Gross, he's joining us, and the president is Guido Tabellini. I invite you all to visit our website and to subscribe our newsletter. Daniel Gross is with us. Maybe he wants to say something. If my colleague Georgia
said that somehow he cannot activate neither camera.
Yeah, now maybe Georgia, my colleague Georgia will help him to open his his mic. Okay, Daniel, here we are. Okay, Daniel, if you want to say something, I was just introducing the Okay.
Now I can. I'm with you. I just wanted to say hello to everybody and especially our speakers, both here and from afar. And I'm really looking forward to your contributions and the discussion. I think now the floor should be given to our speakers. Thanks a lot for the introduction, Stefano.
Thank you, Daniel. Leonardo, the floor is yours.
Thank you. Thank you very much. My name is Leonardo Borlini, and I'm Associate Professor of International Law here at Bocconi University and a Fellow of the Institute of European Policy that our host Stefano has so kindly introduced to us. My task today is relatively easy because I have just to address some welcome greetings to our distinguished guest speakers, and I'm particularly happy that in the very first panel we will have speaking three former members of the WTO appellate body and two former chairs of the same body, including unfortunately the last one so far, because the appellate body, as many people in the audience knows very well now, is in a semi-paralysis, Professor Hong Zhao from the Peking University. I just want to situate our conference saying a few words about what is happening at the WTO in the context of international relations and specifically international economic relations. As many of us know, the World Trade Organization held its 13th Ministerial Conference in Abu Dhabi from February the 26th to March the 2nd, so less than, or actually 1 month ago. And the ministers representing 164 WTO members of very different levels of development and with very different geopolitical views met there to discuss a plethora of very important topics ranging from food security, e-commerce to fishery subsidies, and especially institutional reform of the World Trade Organization, which is one of the core topics that we will address in our conference today, as well as domestic regulations of services and investment facilitation, which have been for long two lingering issue in the negotiations of among member states of the WTO. At the Ministerial Conference number 13, ministers agreed actually on intensifying cooperation and negotiations on several commercial core topics and endorse a forward-looking reform agenda for the organization. They also welcome progress made in negotiations and provide guidance on issues where more work actually needs to be done. Ministerial Conference 13 shows the value, to me at least, the value of a multilateral organization that facilitates exchange and trade relations between so diverse states in the world and delivers some substantive results, notwithstanding the expectations were probably higher. However, it is no secret that the conference took place during a time of widespread geopolitical tensions, including intense trade disputes or tensions between the two leading global economic powers, the United States and China. I have just come back from a symposium held in Seattle where two of the speakers of today also contributed to, Professor Schoenbaum and Professor Washalai from, again, Peking University. And this also, this situation has somehow been, I wouldn't say, or I wouldn't dare to say aggravated, but featured by a shift in the position even from the European Union, who has been a champion traditionally advocating the value of multilateralism, international trade relations, but is now adopting a more cautious and reactive stance, as evidenced by the latest package of legislative proposal issued by the European Commission in January 2024. And it is precisely this topic that our distinguished guest speaker we will address today. So without further ado, I will let the floor to the first panel and its chair, Professor Giorgio Sacerdoti, who is Emeritus Professor of International Law at Bocconi University and also former chair and member of the WTO appellate body. Thank you all.
Thank you very much to Leo, and thank you very much to all the participants and especially the speakers. And this, as it has been highlighted by Stefano, this is a new development at Bocconi, but builds on our specialization since many years in the law of international trade and generally in international trade relations, both from an economic and a legal and political point of view. Now, I am only supposed to make some introductory remarks to this panel, and I will start with what Professor Bollini was saying. Was the expectation for the MC13 high, as he somehow hinted, or were they low? I think maybe they were high a few months before, but then while the negotiation pre-conference didn't yield any perspective of result, these hopes were rather reduced. Very shortly, what did MC13 has been just a passage. What was there has not been finalized, and the mandate is to go on in discussing and negotiating these issues, and maybe with some unrealistic terms and deadlines, like to complete the famous discussions on dispute settlement reform by the end of 24, and we are already in April practically. And so this reflects, in my view, a situation of general uncertainty, of a lack of commitment that has been written to the WTO and to multilateral system, not undermining it, but not revamping it. And what needs is some revamping. When we were younger and were a student of this subject, it was said that the GATT at the time was like a wheel. You needed to have continuous rounds because you had to move to new agreements and new liberalization, not to lose the effect of the previous acquis of the GATT, let's say. And WTO has been unable to do so. The Doha round has resulted in nothing further sectoral negotiation in very few agreements of not such a big importance, in my view, facilitation, trade facilitation for development. The fishery agreement is a provisional agreement. It's not yet enforced because the have not been enough ratification yet, although ratifications slowly are coming in, and it has to be hoped that it will be enforced, but it's provisional because it's not completed by the final agreement within 2 years. Then everything will collapse, and negotiation on fishery have not led to results before and at MC13. Then I would say, therefore, on the other hand, even more, it has been pointed out that what has been decided on e-commerce is really a primer in negative, because it has been decided that this 2-year revolving extension of the commitment not to impose custom duties on e-commerce, delivery by e-commerce of products like films and software and so, will finish after in 2 years. And if there is not a new agreement, that's it. Countries will be free to impose custom duties on these imports. Indonesia, India, South Africa, other countries claim that more and more commerce is done through these means, and therefore they lose tax custom revenues. They would gain custom revenue, although that would be at the expense of the freedom of movement of the most modern and dynamic sector of international trade. And it has been pointed out it would be the first time that WTO, instead of increasing liberalization or locking liberalization, would preside over a reduction of liberalization, the reintroduction of custom duties. So you see, this is a kind of worrying signal. It has been said countries were more interested in their individual position and possible advantages than in engaging in negotiation to find new bases of developing international trade, which would be indeed important in this situation. Then, and I will finish soon, the other development which are sometimes somehow out of the negotiation of MC13, that is, Leo hinted at that, the invocation of economic security to raise new barriers, new controls. Also, the European Union, with its strategic autonomy, was using the anti-coercion instrument, hasn't been used practically yet. I mean, countries are preparing themselves, at least, and sometimes, especially the United States, but also China possibly, putting in place restrictions, selected restriction to international trade, not just towards countries or towards product, but even towards specific enterprises, specifically very narrow sectors like advanced machinery for produce of advanced chips, for instance. And now, in parallel, we have seen also ways of restriction to the flows of investments, of foreign direct investment, both inwards, and that is not so new because this type of screening of golden share has been around sometimes to avoid that key domestic industry would be controlled by foreign companies and maybe transferred abroad, dismantled, technology would be acquired and then profit to competitors. But even now, against friendly acquisition, think of Nippon Steel offering to buy US steel, which is currently being blocked by various authorities in the US. But now we are also to control to the outbound investment flows. And this is also worrying. Now even the European Union Commission has proposed recently, it was this general package, that to start studying the impact and then towards putting a control on outward investment. Now, I am a rather liberalist approach, and I think that trying to deny to foreign countries, foreign developing countries, the benefit of technology which has been developed in the most advanced countries is not a solution. That was the idea of Great Britain before the First World toward Germany to this rather stimulates other countries, and this I think it's a case of China, to on the contrary, to rely on self-development and to increase the speed by which, instead of relying with international and intercompany cooperation, each one will do it by each major country will do it by itself, and then will put reverse restrictions to other countries. So the climate is not very optimistic, I would say. The backbone of international trade is still the multilateral system, the package, the Uruguay package administered by the WTO, but there is an increased fatigue of the system. And I will close, and these points of me are also meant to be suggestion to the speakers of this morning, of this afternoon. It's not that the alternatives are very brilliant. That is the idea of bilateral and regional trade agreements, not just to advance the cause of trade, but maybe to replace the fact that multilateral agreements are stacked, or even the one currently existing at the WTO, are not going very far. There have been, as you know, plurilateral agreements having been negotiated by WTO members within somehow the WTO. The most advanced one and promising is the one of domestic regulation of services, has 70 countries, but it would be non-discriminatory. The liberalization would apply also to the countries which do not participate, but the request to annex this new plurilateral, to add it to the other few plurilaterals that are in the WTO package in Part 4, has been rejected by other countries, notably by India. So such an agreement remains in the limbo. It could be that these countries then decide to sign the agreement just outside the WTO, and this would put it in place, and it would be, of course, a blow. And as to regional, you know that EU-Mercosur negotiation after 20 years are stuck, even if currently President Macron is in Brazil, and the pictures are on today's newspaper that he is picture with President Lula, but I wonder whether they will be able to block this agreement. Other bilateral agreements also with Ukraine are stuck. The French Senate voted last week against the ratification of CETA between Canada and United States, and this fares badly also for this agreement, which has been highlighted as a model also for its investment chapter. And also the US has not much appetite, and the Indian Pacific Cooperation is is an agreement which has no trade liberalization and discipline rules, and it just rather loose political, economic cooperation. So I leave it to this. I think we have a lot of things to discuss, debate, and to have the reflection of the public which is following us. I won't go into the sad story of the demise of the appellate body, which has been pressured by the United States, which has really put in peril the whole dispute settlement system, notwithstanding the MPA as an alternative being enforced not between many countries, although we have had recent cases of production of decisions like the one bit on palm oil between Malaysia and the European Union, but still it's to be seen how much these panel decisions, panel reports if they are not finally confirmed by agreement and adoption by the DSP or remain stuck in existing appeal, will influence the respect of the rules which have been laid down about 25 years ago. Thank you very much, and I give it, no, I can't give it back to Leo because it's for me to chair. So our next speaker, exactly on the WTO dispute system, settlement system after MC13, is for Professor Hong Zhao, whom I welcome, and she has already been presented. She has not only an academic experience and experience as judge at the appellate body, but also as a trade diplomat before for China, and knows well the reality of international trade negotiations and relations. Thank you. Please, Zhao.
Oh, thank you very much, Giorgio, for the kind words and the opening remarks of the general picture of the outcome of the MC13. And I appreciate very much for the invitation to this webinar organized by the European Policy Institute of the University of Bocconi. And it's really a personal delight to join this webinar, in particular to see you and Matsushita, my former colleagues at the appellate body. I hope one day I can bring you to the PKU campus, to my university, so that we can exchange views on all these important matters. I appreciate it because I think it's important for the mind, the intellectuals of the world to keep contact with each other, to follow the negotiation outcomes that the trade officials had brought to us. And the objective and purposes of doing so is to build a consolidation among the mind and of the intellectuals, so that we can form a solid legal consensus that we be able to imagine what could be the future of international law. If you allow me, I can share with you the slide I made.
Yes, of course, Professor. Please share
I need to.
Yes,
I'm not so familiar with it. Let me try to find where is on my how to
Yeah,
do it on the team.
You should find
you can help maybe.
You can find the
So,
button with the share, which is on the
yes,
upper
I see
right.
the share, but I
So it's very close
find
to the icon of,
then you
with your
click
microphone.
on the screen that you should see. Otherwise, we can help you with the sharing the slides.
I think. Have you seen it?
Yes, perfect. That's working.
Okay,
perfectly.
great. So I prepared a little slide actually this morning, and the time is limited, and I just like to focus on perhaps 4 issues. One is the background of our discussion after the MC13, and another historical perspective at international adjudication. And then the challenges, I believe, that is common to all international adjudicating body, and then a few words on the future of the world trade. And let me start by a quote from the Cliff Geese, that law, as professor of law who teaching law at the university, I'd like to start with this. Law is part of a distinctive manner of the imagining the real. And for international law, it is common that a school of international lawyers always believe that international law is something but a legal imagination of the world. And I won't go into detail on this, the group of scholars who believe so. But before we start our legal imagination, let's look at the reality, the real world. I guess it is not, as Giorgio also mentioned just now, it is not very, how to say, we see the world alive and animated, I should say. It is full of innovation, but as well as the problems and challenges, these days. And in the word of Martin Wolf, a few days in his columnist in Financial Times, it is a polycrisis world. And the changes has been the driving forces of all the changes and violence is the change of landscape, the aging population, the change of the climate change, the breaking of technology, in particular the silicon-based intelligence may threatening already the livelihood of and the existence even of the carbon-based human intelligence. That alone to say the geopolitical tensions among big nations. And the risks is that the slow economic recovery now meets with the rising tensions around the world in a few places. And I think this is something reminiscent of what happened in history a century ago. We don't want to repeat the mistake of what happened, in that days, but so how to manage a changing world. There are full of uncertainties. The DG and Koji said the world is never so uncertain that he had ever foreseen in a decade. So how can we manage the changing of the world, the change of the international order? Maybe someone would like to put it that way. So I hope that the people who work in the trade regime would like to see that the trade regime play a positive role in this whole landscape. So that is the whole, I guess, a broader landscape. We'd better keep in mind when we talk about the negotiations after the MC 13. The other thing is a backdrop I'd like to mention is an article, a thesis I wrote last summer and was published by the Tsinghua Law Journal at the end of last year, which is from consent to quasi-judicial, the progressive route of international adjudication and the WTO dispute settlement reform. And I quoted in that page, I can't tell the whole of the idea of that thesis, but just a few lines. I think I quoted the words from Professor Louis Hankins that in relations between nations, the progress of civilization may be seen as movement from force to diplomacy and from diplomacy to law. And I did find the progressive route of dispute settlement of human society, which moves from the military actions to diplomacy and to diplomacy to justice. The three phases I concluded in the paper in the very beginning as the beginning part of the discussion is the first phase of the dispute settlement of the human society could be the law of war and peace, which is the time of Hugo Grotius. And the second phase is diplomatic jurisprudence that, James Brealey, Professor Brealey mentioned about the rising of the international lawyers and the diplomats who, as a group, as a professional group, play a vital role in settling dispute among nations. And the third phase is the professional legal resolution of the dispute among nations, mediation, arbitration, the court or quasi-judicial bodies. So the conclusion is that binding third-party dispute settlement from institutional arbitration to court or quasi-judiciary adjudications is a progressive route, and that route is a progress. I quoted a few literatures from professors who put forward a few criteria in judging what is the level of judiciary, and with the change of the judiciary, the level of the enhancing of the judiciary, the justice, the outcome of the decision are more justified, justiciable. So I think for international lawyers, they always fight. There's a struggle for them, in particular for those idealists. Their view is that whether we should have a court of law or a court of arbitration. And for them, the ideal situation is, of course, a court of law, but we never reach that height. Even the Court of International Justice or the appellate body, who is now in limbo, didn't reach the real level of court of law. I won't be able to elaborate on that too much, and that is why that has been regarded as a utopian. You know, the constitutionalization of international law has been regarded as a sort of utopian. And then I mentioned, I'm teaching international law and international economic law at the law school, Peking University. I once quote this, I read the work that Stephen Schwebel, who is the chief judge of the International Court of Justice, who is from United States. After his retirement, he wrote the work of his book on justice in international law, which I found striking that he quite friendly comment on his work at the International Court of Justice, which I hold quite highly in my heart. The court ruling and consultations in his word has been sound and of high quality, though maintain that there are a few extraordinary exceptions, and has been criticized for elliptical conclusion, which at times are not sufficiently supported by reasons and for insufficient citations of the authority. Very, very recently, due process has been raised, but as a whole, and over the years, the court's procedure and substantive record is very good. I mean that, that remind me, I won't go into detailed studies from my teaching. So that remind me to think about the challenges common to all international judicative body. Any international judicative body may face this challenges, and the judicators do have these difficulties in dealing with these matters. Never there's an international judicating body can escape from those criticism. I think one is that how long does the sovereign state like to confer their consent? For me, that is, of course, that consent may change. And then the second may be how to strike a balance between the independence and impartiality of judiciary body and outside intervention or influence by power politics. I guess I was invited to write an article on international judication and politics by Cambridge University press, and I'm working on. So I'm also thinking about that, how to deal with the situation of constructive ambiguities in the rules of the treaty and the requirement of parties to resolve their dispute over these matters. That is exactly what happened with the appellate body. The appellate body was required by the treaty to address every issue appealed, but at the same time, there are some of those provisions, including those, Article 17.62 of the ADA, those are the inherently embedded constructive ambiguities in that treaty, in the negotiation. So, but if that issue was before the judicator, how do they manage to the challenge to face that challenges? So and how to manage the influence of differences of major legal systems? With that, I'd like to refer to the continental law, the common law, and other legal system, the major legal system. But in particular, one, the precedent that the advisory opinions, for example, even among common law countries themselves differ with each other. I won't go to detail of all those matters, but So for the president, I see scholars who wrote even their remarks in the seminars I organized in PKU a few days ago on March 6th. You know, I'm not sure whether I should mention his name, but I did see that he worries about the Manila process, which provided a solution on how the future adjudicating body at the World Trade Organization treat the president. And he's concerned that you know, for any adjudicating body, that you need to maintain a kind of consistency of the previous decisions. But then in whose hand? What he worried is that does that be better that to change that in the hand of the appellate body to some other's hand? So I mean the challenge for the adjudicating bodies is that almost all, I think in my view, is all the current international adjudicating bodies are only granted with a case-by-case decision authority. But how to deal with the previous decisions? I think all these are challenges that at least plague me through all my days working at the appellate body and even after retirement, facing the current situation for the appellate body. So I suggest that you know, some fair judgment of the function of international adjudicating bodies should be rendered. You know, to me, to settle disputes among sovereign states at the international adjudicating body, and the adjudicatory results having been honored and implemented by the sovereign states are indispensable to the success of the function of international law. I think there should be a high remark, all these international adjudicating bodies, for its contribution to maintaining the and enforcing international law in various areas. I think that job, that work, and that achievement should be honored rather than to be discredited, or the rules, institutions, and practice of international adjudication, in my mind, I have been given in my lectures, in my farewell speech, you know, are the highlight of institutional achievement of human civilization and should be cherished. And I think the appellate body should be treated fairly. Now, the quick comment on the Manila process and its test that has been coming into public. Now, I think we, in general, welcome the process and the text delivered, though it is hidden. It is only recently delivered to us. And I think it seems to be successful in providing alternative dispute resolution mechanism with the voluntary use of tools available for resolving disputes without the need for litigation, including arbitration, mediation, conciliation, and the good offices, etc., etc. This may be, to me, a positive development that could facilitate members to have more options to settle their dispute with perhaps fewer costs and desirably less time, with more flexibilities. And this could be of interest to maybe smaller members and LDCs. I think maybe big members will still prefer the litigation in a more legalistic manner as they see the system in that way. And they have that experiences. I thought more members may have interest to go with the panel and the second stage litigation at World Trade Organization. And the text, the Manila test, also made progress at. That is why I heard the praise on stricter limits on the length of submission. But I'm quite doubtful whether that will be at the cost of the right to defend by parties to the dispute. But there are many other perspectives. I guess it won't be enough time to go into technical details on those perspectives. And to me, of course, and to many, and according to the mandate of ministerials, who instruct the trade officials to continue to work is the appellate and appeal review mechanism, which is, I think, the major missing puzzle in the whole dispute settlement reform. So for me, the post MC13 negotiation, the key of that is to, given the time restraint within 2024, the focus and priority definitely would be on the restoration and the reform of the appellate body, with a view to revive the binding nature of the dispute at the World Trade Organization. And the current appeal to the void is definitely poisoning the whole multilateral trading system. On future world trade, we also concerned, I guess many, including the private sectors, worried very much about the fragmentation and decoupling, which are not in the interest of anybody in the world. Protectionism, unilateralism are harmful to multilateral trading system. Though people may say, oh, days has gone and we need to face the challenges of the adjustment, which is undergoing in the trade areas, we still, I believe, at least for dispute settlement, we are at a crossroad and with the next step. The progressive route of international dispute settlement towards a rule-based system or a power politics based system. I think this is a choice of members, and I still believe members could work out a solution, and I guess it is for the members to decide, even from a longer perspective view of history, what is the best to the best interest of all members, that what sort of dispute settlement system should be re-established and revitalized. I would like to say that for many, a single two-tier binding dispute settlement at the World Trade Organization is a desire and a wish, and I think I hope that could be accomplished by the trade officials. But as an academic, academic circles, what we can provide is the thought, the ideas, and hopefully the trade officials could work them out. Thank you. I think I stop there. Thank you, George.
Thank you very much, Zhao. You gave us a broad picture, not just of the dispute settlement system and its moment of crisis, its function, its value, but also putting it in the difficult moment of multilateral trade. And I appreciated that you highlighted that adjustment is necessary, but fragmentation and decoupling is not in the interest of the world. It's contrary to our ideas and ideals of international cooperation. I give now the floor, before giving the floor to Professor Matsushita, I would like to ask Leo Borlini, how is the organization after the intervention, which I see about half an hour, 40 minutes each? There will be a possibility of questions, and you will run this, I guess, and Stefano.
Professor Matsushita and Professor Goldman will deliver the speech, and then we will have a question-answer question. Professor Goldman have some urgent institutional issues, so okay, we might have everything online. So me and Stefano will organize the question and answer question, which will be probably addressed to each and every speaker.
Okay, so please, Mitsuo, Professor Matsushita is emeritus professor, former member of the appellate body, has written a lot on international law and international trade, has a rich experience. He was somehow my mentor. He was at the appellate body before me, and we must be grateful to this first generation of appellate body members, as they have been called, that set up the system. and with impartiality, independence, rigor, and dedication. And even if this currently there are no hairs in place for this tradition, I think the examples remains shining, as Zhao said, should be cherished and honored. Please, Mitsuo.
Oh, thank you. Can you hear? No, okay, thank you. I'd like to thank Professor Sacerdoti, Professor Bordini, and the Bocconi University for organizing this wonderful conference. Let me get my PowerPoint. Today, I'd like to discuss the two topics in broad context of the WTO and the free trade. Now, one is the national security issue in the WTO context. And the other one is a little bit different topic. This is an extraterritorial application of the export control laws, especially with some emphasis on the United States legislation and the Chinese legislation. We have the experts on the
Excuse me, Mitsuo, and also Leonardo, there is some echo. Maybe you should stay a little bit away from your microphone.
Oh, okay. Can you hear okay? So I'd like to speak on two topics. One is the national security issue. The other one is the extraterritorial application of the export control laws of the United States and China. We have experts on those topics, both from US and China. And so whatever mistake I may have made on the interpretation of US and Chinese laws, I welcome the corrections, suggestions, and comments, and so on. Now about the non-trade issues. What are non-trade issues? Well, generally speaking, we all know that the WTO is dedicated to promoting a free trade and free economy. But actually, if we look at the recent developments in the world trade and the world politics, there are certain developments that require a little bit different approaches. In other words, not only just the freedom of trade, but some kind of exceptions to freedom of trade. And the non-trade issues generally refer to those exceptions. So I'd like to discuss some of those issues today. Well, one topic I'd like to discuss is national security. This is in terms of the GATT treaty. This is the issue of Article 21. And the Article 21 recognizes that the very certain needs and exempt activities of the state to protect itself from outside threat from the disciplines of the WTO GATT. And as far as I know, all FTAs have provisions similar to GATT Article 21. And of course, we know that GATT Article 21 exempts the obligations of any state measure taken in time of war or other emergency in international relations. Now, the one issue here is the scope of this it looks like that Article 21 allows a quite wide discretion to the contracting parties when invoking the measure based on the national security. Now, on the other hand, the recent WTO decisions say that the principle of good faith is there, and this principle of good faith operates to keep the parties in bay. In other words, to prohibit the parties from abusing this wide discretion granted in Article 21. And so we have now the 2 cases, 2 recent cases on the national security. One is a Russian cargo case. The other one is Saudi Arabia IP case. I'd like to say a few words about those 2 cases. Now, about Russian cargo case. Now, in relation to the war between Russia and Ukraine, and Russia prohibited passage of Ukrainian goods destined to a third country through the Russian territory. Now, Ukraine complained that this amounted to an infringement of GATT Article 5, which guarantees the free passage of the products of contracting parties destined to a third country through the territory of another contracting party. Now, Russia denied the power of GATT to decide what the belligerents are, and claimed that this is entirely left to the judgment of the belligerents. In other words, Russia claimed that WTO cannot intervene, cannot decide on the validity or invalidity of the measure of a state taken on the basis of national security. Now, panel stated that the contracting parties do not have 100% free hand in deciding what is national security. And it says that the panel should be able to retain the power to decide for contracting parties the meaning of national security. Now, on this basis, panel examined the Russian measure and decided that the measure taken by Russia, in this particular case, amounted to measures in the sense of GATT Article 21. Now, on this basis, Russian measure was upheld as justified by GATT Article 21. Now, on the Saudi case, now this is about intellectual property TRIPS issue. One of the parties, Qatar, claimed that the Saudi's National Broadcasting Agency infringed IP rights that Qatar has in Saudi because it broadcasts items covered by IPs owned by Qatar in Saudi. It claimed that Qatar's request for relief at Saudi civil court was blocked by Saudi's interference. And Saudi said that the measure in question amounted to a measure taken in order to deal with wartime or emergency, as provided for in the GATT article and TRIPS article 78b3. And panel held the measures were permitted under this TRIPS the provision. Now, Qatar appealed the case to the appellate body, but still, as we discussed already, the appellate body is still inactive at this point, and there is no decision coming any sort on it. Now, by looking at those 2 cases, we can say that There's ambiguity in that article 21. The key word here is get article 21, which it considers necessary. So this means that the country or state invoking national security can decide what is national security for that country or for that state or not. So this is one of the questions. And the other question is other emergency. It says that get Article 21 exempt measures taken in time of war or other emergency. Now the war is clear enough, I think. The other emergency, this is more general and exact the reach of the word emergency, which is other than war, is not so clear. So this is one of the questions I have to be studied in future, I think. And then if you compare the GATT articles 21 and 20, I have just a couple of comments. Now, GATT article 20 has support. So we know that this chapeau says that the contracting parties who invoke provisions of GATT Article 20 are subject to the requirement that such measures are not applied in a manner which constitutes a means of arbitrary or unjust discrimination. This is one of those requirements. And the disguise, it cannot be disguised restriction on international trade. So this is a chapeau of Article 20. So in short, this chapeau provides for the requirements that the provisions in Article 20 shall not be abused or misused. Now, in contrast, the Article 21 has no chapeau. So the question is, what the implication of this lack of chapeau? Does it mean that WTO members can use the national security measures freely or any limitation? Of course, I don't think that is true. But John Jackson did say a long time ago that the Article 21 provides a dangerous loophole, and there is little that we can do about it. So this is what Jackson said that in the law of the GATT about 50 years ago or so. But I think there is it's clear from reading those two the decisions made by the panel so far recently that there is a good faith principle operating. And in the Russian cargo case, the panel warned that the good faith principle required that the Article 21 should not be abused, and its good faith application is necessary. I think that this good faith principle is inherent in the GATT Article 21, even if not that clearly written in the Article 21. So I will say that this is an implied requirement of it. Well, but of course, there is appears for the emphasized that the language wording of the WTO agreement is important when interpreting the treaty. So this is of course one of the requirements of the Geneva Convention. That the wording should be respected, and wording is different between Article 21 and Article 20. So how can we reconcile this from the principle of the literal interpretation. Well, I don't have clear answer to that. But the only the comment I can make is that the good faith principle is inherent in all of the WTO agreements. So the affiliate body and panels and any other the agency or the organ that interpret those two provisions should read into GATT Article 21 of the good faith principle. And I think ideally there should be guidelines for interpretation on this issue. And if the GATT Article 21 can be amended to include the chapeau like the GATT Article 20, that would be better. But I think politically it would be very difficult to amend the GATT provisions. Now, alternatively, WTO Secretariat or some academics and so on can draft a set of guidelines for interpreting GATT Article 21 and delineate by illustrations the kinds of situations in which GATT Article 21 can be invoked. Now, guidelines should contain for example, the meaning of the war and other emergencies. So this is one, and also they should contain the warning that contracting parties should not overuse that Article 21, and also use of trade remedies as much as possible. If the real purpose is the protection of domestic industry. So, for example, if you look at the United States, which invoked the import tariff on the steel and aluminum, by invoking what was it? U.S. law. I forgot what the name of that law. Article 232 of the Trade Expansion Act, I think. Now, so that's one of the cases that occurred recently about national security. But I'm not an American lawyer, so I wouldn't say anything about American law with authority. But it seems to me that that kind of case could have been dealt with by either anti-dumping or countervailing duties or safeguards without using the national security provisions. Now, I'd like to turn on different subjects. This is a little bit different, and this is in a strict sense of the term. This is not within the framework of the WTO law. But I think that this is an important issue, and so I'd like to say something about this topic: extraterritorial application, export control legislation. Now, in U.S. you have Export Control Act, and in China you have export control orders, and both of them are the applicable extraterritoriality. And so both U.S. and Chinese export control legislations apply to re-export of product to a third country if the product to be exported is controlled by the U.S. or Chinese law. Now, so I have here some example. U.S. government, for example, designate product X as a controlled item and prohibit its export to country A. If, for example, a Japanese company import product X from U.S. company and re-export it from Japan to China, or any countries designated as a prohibited area for exportation. Such export is prohibited by U.S. legislation. This is one type of situation. And Chinese export control legislation applies to re-export of a product subjected to the Chinese regulation if it was imported from China to a foreign country and is re-exported from there to a third country. Well, so this is the type of situation I'm thinking about. So this is the little diagram I draw to explain. Now, so U.S. government prohibits export to China. And then here the third country, where's Japan or some other countries. And company X is here, and U.S. government, by way of extraterritorial application, prohibits company X from exporting the product to China. And then the Chinese government invokes the Chinese law and impose penalty on the subsidiary of the company X for the complying with the U.S. Export control order. So this is one type of situation. I have here some explanation, but I will skip this because of because what I would say here is the same thing as what I wrote in this diagram. Now this is another diagram. Here, China invokes export control legislation and prohibit the exportation of certain products to China. To the United States. And then company X, or say Japanese company, they will get the order from the Chinese government not to export the product to the United States. So the company X will direct its subsidiary in China to stop export the product to the United States. Then U.S. customer company Y. Now, this company will sue company X either in the United States or in Japan for violating or infringing the contract between the Y and X with regard to the certain product to be exported from China. So this is a second type of situation I'm thinking about. So what are we going to do about this kind of situation? Now, one way to deal with it is the blocking statute and clawback statute. Now, in order to deal with extraterritorial application of the United States export control law, in 1950 to 1912 to 80, U.S., UK, Canada, Australia, and some of the countries enacted blocking statute and clawback statute to prohibit their nationals from complying with U.S. laws, which is applied extraterritorially and affecting re-export from those countries. So those happen. Now, in 2018, in order to counter extraterritorial application of a foreign law, EU Commission adopted an update of the EU blocking statute, providing that any decision under a foreign law which is applied extraterritorially is not recognized in U.S. authorities. Well, now, actually, this is what I read in the Professor Bocconi's the article, which he kindly sent me just a couple of days ago. I just read it in great haste, and so I may have misunderstood what he meant in this article. So if so, I would certainly like to apologize, and I would like to get corrected by Professor Bocconi. Now, clawback statute authorizes the countries affected by extraterritorial application of law by other countries. In respect of two things, to issue an order for non-recognition of any order in their territories, which they see as infringing their sovereignty. So this is one. And B is to allow their nationals to claw back the damage which they have been ordered to pay in the infringing countries. Now, if we look back into history, I think it was in 1980, there was a big case in this regard called the Siberian pipeline case, where the U.S. prohibited certain kind of export from UK and France and so on to the Soviet Union. And the UK.
Excuse me, Mitsuo, but you have a few minutes left.
Okay.
Okay, thank you.
In a couple of minutes. So what are we going to do about it? Well, the other thing is to establish principle of jurisdiction in customary international law. Now, there are 5 principles in customary international law about the jurisdiction: territorial principle, nationality principle, protective principle, universality principle, and passive nationality principle. Probably the territorial principle and nationality principle and protective principle are the relevant as far as our purpose here is concerned. And the objective territorial principle says that the jurisdiction over conduct initiated abroad can be established if the effect of that conduct occurs within the territory. And the question here is, what is the effect? How wide should the effect be interpreted? The rule is not clear in the international law yet, I don't think. But the scope of the effect in the practices of nations, U.S., China, EU, China, and U.S. Is expanding. So I think in near future there will be a rule or customary rule in international law, which has been a little bit more expanded as compared with what we have understood to be a territorial jurisdiction before. Now, I will stop at I will just skip this protective jurisdiction and so on. And just my last comment is about notification and consultation. So I think it probably is a good idea to think about the practical way of avoiding and resolving the jurisdictional conflict that results from extraterritorial application of the export control law or any law for that matter. So one is advance notice and consultation, and those are not the ultimate the resolution of the problem. But I think that those are a good way to mitigate the severity of the conflict that may result from the extraterritorial application of the domestic laws to conduct which occur abroad. Well, this is about all I wanted to say. So thank you very much for your patience in listening.
If I may add, Professor Matsushita, thank you very much for your, I didn't really want to interrupt, but thank you very much for your insightful presentation. Unfortunately, we were not able to see your PowerPoint, but if you want to share them after the conference, we will upload it on the webpage of the conference, maybe the same this in between the 2 panels today, so that all the audience can assess to the problems that you explain about export control of the extraterritorial application, and especially the practical way to somehow overcome this issue.
Oh, thank you very much. I will do that.
Thank you. If you send them to me, I will make sure that they will be uploaded right away. Thank you.
Okay.
Thank you. Thank you very much.
Thank you very much, Mitsuo. It was also interesting your rich historical perspective that many of these issues that we face today are not new, and at the time of the Cold War, before and after, we had witnessed these interferences with trade. I give the floor now to Professor Matthias Goldman. He's too young of having been already a member of the appellate body or these bodies, which alas are of the past, but I wish you well for the future. He teaches at EBS University in Frankfurt. I'm not sure what EBS is, but he may tell us, and he's a specialist also in international comparative law with a special interest on trade matters and non-trade issues concerning trade matters. Please, Matthias, thank you.
Thank you very much, Professor. Thank you, colleagues, for having me here today. I'm actually teaching at EBS University, which is in Österreich-Winkel, which is near Wiesbaden. So Wiesbaden being the capital of the state of Hessen, if you know. And it's actually a partner university of Bocconi. So every year we have got students from Bocconi in our place near Wiesbaden. So I'm very happy to be here today. I might be an unusual pick, but I think my role here is more the perspective of an EU lawyer and someone who's like looking at trade from the outside, especially from finance. And I think there are some interesting things that you can say in that regard. I also have a PowerPoint, a very short and very basic, and I'll try to select my, and I hope you can see it now. Can you see it?
Yes.
Okay. And if I go like this, you also see it? Is this now the second? This is the first slide. And is this the second slide now?
Yes.
Okay. I can't see you very well right now. Okay, I think it will work like this. Okay, so yeah, you see here, and there are two contrasting symbols on this screen, and that is also because I think that EU and the Ministerial Conference 13, there were some conflicts, some oppositions here, and maybe some unexpected ones. That's why I thought I should pick two different color schemes. Now, what is the background of the EU position? It is what has already been mentioned by Dr. Satyarthi in his wonderful introductory remarks. It's this open strategic autonomy that the EU came up with in 2021 as a trade strategy. It has been around already for a while. It's actually a strategy that comes from the security sector. Now, what is the point about open strategic autonomy? I'll break it down into three terms: open, strategic, and autonomy. The question is, how open is the European Union really? Actually, the open strategic autonomy is a strategy to close the union rather than open it, or let's put it like that, to keep it open despite difficult circumstances and a changing trade environment where anything goes. Liberalization is no more the order of the day. So the way the European Union wants to open is by preserving its values. But so the values of the EU, which are epitomized in Article 2 of the Treaty on European Union, are kind of the backstop against which the EU wants to measure its engagement with other blocs, in particular China, where it thinks that it doesn't really share the same values. And these values are, democracy, the rule of law, fundamental rights, etc. So all these good, democratic liberal purposes. And so the idea is that we open up to the extent that any of these values are not endangered. Actually, this is quite in line with the jurisprudence of the European Court of Justice, which recently has used Article 2 quite a bit, also in internal matters concerning recalcitrant governments like Hungary and Poland. So you can say quite consistently, it's quite consistent of the EU if it bases its opening on Article 2, on its values. But we will see to what extent that is really a reality. And that brings me to my second point: strategy. How strategic is the EU trade policy under this strategy of open strategic autonomy really? In that regard, I think it depends a little bit on where you look at. If you look at, for example, industrial policy, you can see quite some strategic planning here. The EU is trying to keep its independence, and that means also the preservation of its values, by investing in crucial areas like chips, raw materials, and batteries, climate technology. So I think the investments are quite strategic. If they are always in line with the values is another question. Concerning raw materials, we have some serious questions here, and also people in, for example, the Sahel have very serious questions to the EU whether the trade deals or the raw materials deals concluded by some of its member states really meet these goals. But at least I could say, you know, from an EU perspective, there's something like a strategy. That becomes a lot less clear. That image of strategy becomes a lot less clear if we look at trade defense measures. Protection against foreign investments, against takeovers, against procurement deals that the EU thinks are not in its interests. And there, over the last 5 years or so, a couple of regulations have been adopted. And what one can say in the brevity that I need to do it here is that I don't really see a clear strategic line. What I see is a strategy of anything goes, a strategy of we will know it when we see it, a strategy of very widely phrased general clauses under which the EU is going to adopt trade measures, and it's not really consistent, not even with international law. There have been many cases where, you know, trade measures of the EU have raised questions under international. So I think this is a lot less clear. What is also less clear, that's the last thing on the strategic point, is the developmental concept that the EU wants to pursue on the globe. All trade defense measures or all, you know, strategic industrial policy planning instruments somehow need to take into consideration to what extent they are affecting legitimate developmental goals of developing countries. And as we see it, the EU is really prioritizing its own interests, and I don't really see a clear developmental agenda, which is very difficult to have. And it's very difficult to say, you know, what is a legitimate, let's say, subsidy for development and where does protectionism start? Because it always can be both, but I don't really see a clear line here. Which brings me to the last point, autonomy. Question is, how autonomous is the EU really? Well, according to its plan, its trade strategy, it can be autonomous if it respects its values. But quite honestly, and I think the Ministerial conference is a good example for that, quite honestly, the EU is relatively small. It's having a shrinking part of global trade, and it seems that the EU wants, with its strategy, to be a big player, a player that is at the same level as China, India, the BRICS, or the United States, like a third bloc. But in reality, the question is really whether EU can play hardball or whether it wouldn't be better off in trying to find alliances, especially because we now really have doubts about the EU's strategic autonomy that reach very far. If you look at the war against Ukraine, it's very clear that the EU alone is not even able to defend itself and relies on support from elsewhere. And for that reason, I think that the trade policy strategy, which predates the war in Ukraine, is even overly optimistic if it comes to the autonomy of the EU. So the EU really needs partners. Yeah, that's what I want to say. So if you look at the open strategic autonomy as it was drafted, and not so much at reality, you might expect something like that to come out of the ministerial meeting, like a confrontation, the EU as one of the big players confronting the United States or China. And what surprised me or didn't surprise me is that the confrontation that we saw at the ministerial conference was really a bit different. The confrontation at MC13 was really, from an EU perspective, between these two people. Valdis Dombrovskis, the Commissioner for Trade, also Margrethe Vestager, who's for competition, and Goyal, the Indian Minister for Trade. So what we saw, the main conflict line, that we saw from an EU perspective was not EU trying to fend off Chinese subsidies, or EU and US getting again into a conflict about steel or about tariffs, etc. What we really saw was a conflict between the EU and states from the global south, led by India in particular, but South Africa has also played a role there. And what is the reason for this conflict, and what do we make of it? Well, the reason for this conflict is, first of all, the selection of issues that were really up to negotiation. Had there been negotiations on industrial policy, we would, of course, have seen a different confrontation, a different constellation, and there would have been much more ongoing between EU and China, but that was off the table. Dispute settlement, I think, was one of the few issues where there was really a transatlantic conflict. Others have spoken to this before already, so that is one of the issues where we actually saw a transatlantic conflict. But there are many other issues that were selected where this confrontation between the EU and the global south just was in the center. And I've selected 3 issues here: tariff exemptions for electronic transmissions, the EU carbon border tax adjustment tax. The tax is missing on the slides. I'm sorry. I don't know where it fell off. And agricultural issues, and there in particular the highly controversial issue of stock taking, of public stock taking of foodstuffs. Now let me go through them one by one. What is the problem and what is the cause of the confrontation between EU and the global south? I think the key cause is that the EU is still stuck in market thinking, in total market thinking, more or less. Maybe a bit of polemical exaggeration here. Whereas the global south is advancing public interests, which are, always notoriously difficult to distinguish from protectionist measures. But I would say that in general, the EU is still stuck in 1990. Or in the 1990s, in many of its approaches. Take a look, for example, at tariff border exemptions. Tariff exemptions for electronic transmissions. So the idea is that anything that you buy and that is delivered to you online is exempt from tariffs. And the EU says, well, this is fantastic policy because generally we are exporting these goods, not as much as the United States and other jurisdictions, but still the EU is thinking it's benefiting from that if there is tariff exemptions from that. And this is justified by the idea that, it will help to develop, it will help other countries to develop. It's the idea of a kind of a trickle-down growth at the international scale. And many countries from the global south now have doubts about that. They say, well, to build up an industry of their own, and we know that IT is a crucial industry, it's a key industry that will affect many other branches, and to build up an IT industry of their own, they actually need protectionism. So this was highly controversial, and at the end, the EU is celebrating this as a negotiating success, what is just, a carrying on with a preliminary compromise. So there you see how they celebrate in their market thinking something as great, that there is no tariffs, whereas we don't really know whether it's good for development. It really depends on how you approach the issues. Let me come to the second issue, which is on the EU carbon border tax adjustment. Now everybody knows that since October 2023, the EU has enacted or has begun to implement its carbon border tax adjustment system, which means that producers of goods imported into the EU are subject to this tax, which is meant to be a remedy for the fact that EU producers within the EU are subject to a carbon trading scheme. And it's there's a certain phase in. At the moment, it only affects some branches, and that will spread. One big problem with this scheme is that there are no exceptions for developing countries. Now, you could say, well, environment concerns us all, and maybe a carbon border tax adjustment is not the place to take into account the role of industrial countries in in global warming or in climate change. On the other hand, the problem is that much of what is being produced in other countries, in the global south, outside of the EU, is being produced for EU consumers. So what the EU has done in the past 2 or 3 decades was basically to reduce its carbon footprint by engaging in trade, by supply chains that have been internationalized. So it is a bit of a problem to say, well, we're selling you supply chains and international trade that is related to it as a developmental strategy, and now we are kind of taking away an important part of that advantage by this carbon border tax adjustment. So the question is really, shouldn't there be recognition for development countries? And that could also be done. You don't really have to reduce the tax because we all want to reduce carbon dioxide, but what could be done in a smart way of meeting developmental goals while saving the climate is that you use the funds that you get through this tax for developmental purposes. That is one proposal that was made, but the EU rejected it and is going ahead with unilateral measures. Unfortunately, I was not expecting much from the Ministerial Conference to come out of it because unfortunately at the last COP, it was accepted by UNFCCC, by the UN Framework Convention on Climate Change's state parties, that measures, unilateral measures meant to protect the environment should not be considered as a arbitrary or unjustifiable discrimination. So the baby has been poured out with the bathwater already, I think. But you see again how the EU is kind of stuck in a trade concept where it thinks that everyone is more or less the same, so we should apply the same conditions to developing states as we apply to us, not seeing the connections or not wanting to see the connections and not wanting to see the global responsibilities which are actually shared, and where you need to think development, trade and climate together. You cannot single out one of them alone. So you have to give greater leeway to public interests, in other words. So that's my second criticism of the EU position on that, which it didn't really it caused some frustration, in particular in India, but it didn't really lead to any result. And now the big thing that many have discussed, and again, George Sacerdoti has mentioned that, is agriculture and the public stock taking. Just to recall, this is a very old dispute. The question is, to what extent are countries, especially developing countries, allowed to store foodstuffs at a subsidized price? That's what you could say. I mean, there's different ways how you can organize and implement such a regime, but the idea is that there's subsidized prices. And originally, like if we think back 20 years, it's as old actually, one of the major reasons for doing so was to support small farmers. A very clear public interest, but then you can see, of course, there is a certain conflict with free trade. Yeah, so that is why such measures were limited initially in the agreements to 10% of the production, of the entire production, measured in terms of 1886, 1887 values. So it's a kind of a historical reference that one needs for one uses here for what is allowed, and that did not suffice. Very quickly already, it did not suffice developing countries to have enough in stock. Also, because they have many problems with farmers that are subject to climate change. There is population growth, so you can see that farming nowadays is not really anywhere near it was in 1986. And so what came up here is the Bali decision in 2013. It was a sort of a peace agreement where they just prolonged allowances for developing countries, basically said that we are not going to intervene in it. We are putting this on hold until we reach a final solution for public stock taking. And now India was pressing for such a final, a permanent solution on public stock taking, and the EU was holding against it. And there were some compromises, but ultimately both of it, all compromises failed, and both sides are blaming each other. And again, I need to say, probably I'm not a very good advocate for the European Union, but I don't really see why they stubbornly insist on a position that, again, is based on the total market idea. Yeah, they say, well, these stock-taking things, measures, they are, of course, limiting and restricting a competition to some extent, or the market to some extent. But between 2013 and 2024, something has happened. 2013 being the date of this Bali decision, this Bali compromise, where it was said that, let's accept that. And I think what happened in between builds a very strong case for stock taking and for subsidized prices that go with it. Why is that so? Because we've been through a pandemic with serious interruptions of supply chains, and we've seen the crisis in Ukraine, which has led to an energy crisis and also to a crisis of foodstuff supplies. And both of them built a very strong case for stock taking, for managing essential goods by governments. The EU itself has done some of that in relation to its energy price measures, where it, you could say, in an untechnical sense, subsidized consumers. And the question is really whether one should not allow developing countries to do that to a much further degree. That is actually a demand from developing countries that reaches back to the new international economic order, like 1970s. That was already on the list to have of the NEO proposals and resolutions, to have measures in place for raw materials, and that also concerned foodstuffs, energy, of course, but also foodstuffs, because at that time many people in the global south were all too aware of famines that were caused by inappropriate provisions. So I think there's a very strong reason from, I would say a human perspective. People need something to eat. You can also say that if inflation is the problem, there's even still a cause to be made for these subsidies, because anti-inflationary measures like higher interest rates, they only function very indirectly. And what we've seen now recently with these skyrocketing prices for energy and for foodstuffs is that you need immediate interventions, in particular in developing countries where people don't have many resources, where they cannot shoulder higher prices and wait it out until a few months later inflation goes down. So you actually need these kinds of provisions, and I think you cannot just say that this is a measure that you look at from a competition angle. That is all I wanted to say on these policies. So as you can see, to summarize, that EU market thinking is really a problem here. I think that this market thinking is really related to the EU's position of seeing itself as a bigger actor than it actually is. And the question is, what could EU do? That's my last slide. The question is really if EU shouldn't change its strategy and maybe consider being less open, but in a more strategic, fairer, more balanced way that takes into consideration developmental and environmental concerns at the same level and tries to defeat unilateralism. Yeah, this open strategic autonomy at the moment, it's quite unilateral what they're doing in so many respects. And I think a strategy that might be more useful for a shrinking power like the EU is to seek partnerships and not to exacerbate conflicts with the global south, and also to allow making connections and making deals across several negotiating issues. Yeah, for example, tariffs on electronic transmissions could be connected with a deal that you strike on public stock taking. Yeah, the EU rejects that quite vigorously, probably because it thinks it can maintain its unilateralism if it doesn't connect these issues. But if you want to build partnerships, you probably have to allow connecting these issues, and you might end up better off. That was it from my side. Thank you very much for your attention.
Thank you very much, Professor Goldman. I think your intervention was quite provocative, because we tend to think in the EU that we are the good guys, that we are open to linkages, to connect trade with human rights, protection of the environment, the regulation on deforestation, the one on due diligence, and there are the market and big business interests that are contrary to this approach. Now you tend to tell us that the whole of the EU has a market approach. It's not very open to let's say, state intervention in the market, like maintain a public stock taking and so on. But we'll open the debate on this. I'm not very familiar on how to give the floor. Will Stefano take care of this?
Yeah. We will
let's
take
say,
care.
how long do we have? Half an hour or so.
Yeah,
right?
Thank you, Professor Sacerdoti. Yes, we have half an hour, and the idea is that you can either write your question in the chat so that we can collect them and ask the speaker to reply, or you can raise your digital hand in order to intervene directly. You can use both options. The only request is to be brief, since we have many speakers and not enough time to go too much into the details. So okay, we have Elisa Baroncini. Maybe my colleague Georgia can activate her mic, and so that she can speak.
Well, first of all, let me thank the organizers, so Professor Giorgio Sacerdoti and Professor Leonardo Borlini, for having putting up this very timely and very much needed conference with so many great experts. And I have basically two questions. The first one concerns the dispute settlement mechanism reform. By Professor Hong, we received a very complete overview of the dynamics that the crisis and the suggestions to improve the system have known in these last years. So I wonder, what is your opinion about the use of the MPIA, so the multi-party interim arbitration arrangements in this interim period of blurring procedural situation, and whether you foresee or you know that non-MPIA parties think to use a similar instrument to the MPIA to have a sort of appeal in this current state of the blockage of the appellate body. So this is the first question. And the second question concerns the dispute settlement mechanism in the plurilateral trade agreements. So we know that the European Union, maybe Professor Goldman can step in this, we know that the European Union tried to show the way in which the international rule of law could be promoted also through this regional dispute settlement mechanism. But then after some initial efforts, it seems that now everything is quiet. So I wonder whether what are your thoughts, your ideas about this, whether you have a comparative perspective with what the United States are doing in their plurilateral preferential trade agreements, and what do you think about the instrument of the single entry point, that involves civil society in order to enforce sustainability issues promoted at bilateral, multilateral, also at unilateral level by the European Union? Sorry for being so long.
Thank you, Elisa Baroncini. We have another question in the chat. I cannot try to have the right pronunciation, but Onur Gakdar Arantas is a question about CBAM to Professor Goldman. How do you think the proceeds from the CBAM will be spent? On intra-EU sustainability or extra EU developmental aid? I just remind you that we had a seminar on this with YEP. You can find a very interesting piece by an Indian economist, Partha Sen, on our website that we can share, where he exactly points to this issue that we are not helping with the global south to comply with the environmental requirements that we are creating. Okay, is there someone else with the raising hands so that we can collect a couple of other questions and then we go back to the speakers? Leonardo, obviously you can take the floor. But you are mute. Okay,
yeah,
now we can
thank
hear
you very much. I have a couple of questions myself, one to Professor Matsushita, one to Professor Goldman. To Professor Matsushita, if you can hear me, I actually would like him to not elaborate, but just probably restate, because we had some interference with the audio, about the practical ways he suggested to overcome the issues that the new export controls are determining. And for Professor Goldman, I was extremely fascinated by his presentation, also because I share many of his concerns regarding a certain inconsistency of the European declared trade policy right now. I just was, and that's very brief, I'm wondering, because this is my stance, but I don't know whether he's correct or is along his own perspective, whether the inconsistency of the European trade policy is also determined to some extent to a reactive stance that the European Union and the European Commission particularly are having right now. And I'm referring specifically to the different instruments or defensive instruments that the European Commission has either achieved to have in form of proper legislation, or has put now forward in 2024 package regarding these are many. You mentioned some, we mentioned others. Problem is that for obvious reason of time constraints, we cannot really go into the detail of the entire package, but many of these packages are, to me, many of these pieces to me resemble those that the United States have already adopted. So my concern about the reactive stance is pretty much about that, and how these determine the possible, or actually what I agree is a very inconsistent or somehow an inconsistent framework, general framework of the policy of the Commission. Thank you very much.
Okay, maybe we can, I don't see anybody else, so maybe we can go back to the speakers, maybe starting with Professor Goldman.
Thank you very much for many questions. Professor Sacerdoti, allow me to come back to your mention of, or to your reaction on my admittedly provocative and probably polemical presentation. Of course, the EU is pursuing public interests in its own policies, but the main point, maybe that's how I should drive it home, the main point is they want to respect public policies on their own terms. And I think this, the Due Diligence Act that you mentioned is a wonderful example for that, because of course it is intended to protect public interests, but by the terms the EU is defining and imposing on its companies. And if you look at, or if you listen to, people from non-EU countries that are affected by that, what you can hear quite often is, why don't you let us do that? Or why don't we do it in an international fashion? Why do you have to do it unilaterally? Also considering that by now we have got different such laws that are in force already, so it's quite a burden on us, and we don't really know what where we should look at. Not that the standards are totally different. The standards are normally international standards, ILO standards, and so on. But the reporting duties are quite different, and so that is what I mean exactly. They want to preserve public interests, but on their own terms. And as a consequence of that, someone else was saying, "Hey, I have a public interest here. I want to be protected," is being shamed as a protectionist, and that is not a good way of dealing with it. And Elisa Baroncini, yeah, you mentioned many important things. Is the EU still this promoter of international law if we look at trade? Well, I'm not so sure if trade is really the best way of looking at it. Well, in the 1990s, you probably could get away with an EU attitude. But let me recall that, as you all know, the EU has always been cautious not to give direct effect to trade rules in its internal legal order, at least for the purposes of damages. So it always has approached the rule of law in trade relations with, I would say, a political emergency valve integrated in it. And I don't think that this has fundamentally changed, but the problem is that the EU is now weaker to enforce such an approach and get away with it. The single entry point, I think, is a very good thing. I mean, it really streamlines things a lot and also allows the EU to be more efficient. And I think, in terms of shrinking EU powers, this is really to be welcomed. I have nothing that I could oppose to that. And maybe if the EU goes back to that, to more respect for the international trade order, it would also be helpful. But I don't really see the EU as a big defender of international trade. If you just look at some of the judgments of the ECJ or the General Court on trade defense measures, they are very often super perfunctory in their analysis of the international trade law, and that alone is already a problem. So again, you have got this internal external difference in the EU, which is kind of pervasive. I mean, it really ties in with this idea of EU legal autonomy that the European Court of Justice has advanced for since times immemorial, or since a couple of decades. And it really means that we make our own rules internally, and what we do externally is a different thing. Which brings me already to Leonardo's point. Yeah, I should probably include the 2024 package, and I agree with you that it is reactive in many respects. It's interesting that they're including security now in the title, economic security. So that really shows how defensive it is and how much they're trying to catch up with the others. But again, that should be a reason to recall to the EU that now in the 2020s, it is more a recipient of trade rules than a maker of them. And that should make you recalibrate or sort out your priorities differently. Do you really want to go into a big fight with India on almost any issue if you are already in a defensive position? Maybe not. It's just my opinion. I don't think that in the long term it's a brilliant strategy. So much on that.
I completely agree on that. So it's not.
Isn't India also in a defensive position? If I may intervene, and also other developing countries, they tend to defend somehow similarly their own position and don't engage in, I don't know, in having an international stockpiling for emergency of products. They think at their rice produce and their rice holding. There was a clash between India and Thailand at MC13 because Thailand objected to the policy of India. Was also in the newspaper. So I see a shift to unilateralism by all sorts of countries, not to speak, of course, of the US. Sorry, then who has to? A question was for Professor Matsushita, I think, by Professor Bollini.
And then there was also I guess there were two questions for Professor Honjao by Professor Baroncini. And I added a question to Professor Honjao in the chat.
Let's start with Mitsuo. Mitsuo, are you there?
Okay, thank you. Can you hear? Yeah. Thank you, Professor Bornini, for your question and comment. You speak about the importance of a practical way to resolve the conflict issues. That is prior notification and consultation. Now, I'd like to speak a little bit about the experience in the area of competition law, where this was a very important issue in the past. So of course, we are not today discussing the competition law issue, but this as far as extraterritoriality is concerned, this question is, I think, is relevant. Now, in 1964, there was the ILA conference, International Law Association Conference in Tokyo, where the extraterritorial application of the competition law was one of the major issues. And I was at the time the graduate student and attended the conference. And then in that time, the United States was the only country where the extraterritorial application was made. And the delegates from European countries they criticized the U.S. practice by saying that this is the over-expansion of the national jurisdiction and so forth and so on. And strict territorial principles should be established. So that was the whole tone of the conflict. Now, in 1968, about 4 years later, there was another conference of ILA. That's in New York, I believe. And I didn't attend that conference, but I read the report of it. And then the situation is very different, because between 1964 and 1968, the EEC, the predecessor of the EU, started extraterritorial application, and so that drastically changed the scene. And then the emphasis is to recognize the extraterritorial application, and how to put a limit to it. So I think this shows that issues like this is a legal issue, but I think in essence it is close to political issue. And so so what happens later is that the ILA and other international bodies and so on try to establish some kind of principle of international law with regard to the jurisdiction. But in fact, all of them didn't work so well. And eventually, they came up with the practical solution. That was the prior consultation and also prior notification and consultation, and if possible, the convergence of the domestic laws. Those three things should be more emphasized than just discussing abstract principles. And so nowadays, in the area of competition law, there is very little conflict of jurisdiction because harmonization has been achieved to a large extent. And then the OECD and also ICN, International Competition Network, those two have been instrumental in bringing the countries together in prior consultation and the prior notification and consultation. And that de facto resolved the most of the issues in that area. So I think that we can learn something from that experience and apply it to the area of export control. Of course, export control is more political than competition law, so we cannot probably introduce everything that happened in competition law area and bring it into the export control area. But I think we can learn that instead of rather than staying on the abstract principles, it is better to focus on some practical ways of resolving the issue. Well, this is the comment I have. Thank you very much for your question.
Thank you very much, Professor Matsushita. And now, if I can, Giorgio, I will let Professor Hongzhao to reply to the two questions that Professor Baroncini made. And if I might add, because I'm very interested in your opinion, I wrote a very brief question on the chat for you, and which was related to one of the points that Elisa made, meaning the possible role of dispute settlement mechanism in the so-called new generation free trade agreements. I just wonder whether, as a privileged observer and a renowned expert, you might tell us your perspective on that, and specifically, you might also share with us your view regarding the position of China in the possibility of creating or setting up dispute settlement mechanism at plurilateral or bilateral level in the free trade agreements that China is concluding or is negotiating. Thank you very much.
Well, thank you, Giorgio. If you allow me to respond directly to Leonardo's question. Well, it is quite interesting perspective, as you know, that China may be the most steadfast supporter, promoter of the multilateral trading system, and we hold multilateralism very close to the heart of the Chinese, and this is from a kind of a bottom-up, perspective of all the international trade circles. The enterprises and the trade officials and the high-ranking decision makers all hold closely to the multilateralism. China did participated, I think, a number of maybe 19 FTA, RTAs. Some of them consist a sort of dispute settlement, but I think nonetheless there isn't a kind of a very active application of those dispute settlement. And another dispute settlement mechanism China is a part of is the MPIA, the multi-party investment international dispute settlement. So as far as on the China's perspective, I think it is always that we believe a single two-tier binding international dispute settlement at the multilateralism at the World Trade Organization would be most desirable of all members of the WTO. But given the difficult situation, China may stay with the multi-party dispute settlement arbitration, the appeal arbitration approach of settling dispute among WTO members who are party to MPIA. But other than that, China is not, I guess it's less innovative. Maybe we should also learn from others and in thinking about other approaches in settling disputes. But China is also starting to have more cases under the ICSID convention. China don't have much cases due to various reasons, but recently we have a few cases. In particular, one we have the new generation of BITs, and China also. I think that there are cases rising under the investment treaty, so perhaps that may provide opportunity for international lawyers to be part of that process. I hope that is okay for you.
A very, very insightful perspective. Thank you very much. Also because we have many dispute settlement mechanisms on paper in many free trade agreements concluded by European Union, US, Australia, and very few working now, so operational. So there is this hiatus between the possibility of having already established on paper the mechanism and then having them functional. Thank you very much for this very insightful comment. Thank you.
Okay, I think we have still some more minutes. Does someone want to ask other questions or to write in the chat? I mean, we are still incredibly more or less on time. I think that Professor Goldman has to leave, so we really thank him very much.
Very sorry. Yeah, thank you very much for having me. Have
Thank
a good
you
day.
so much.
It was a pleasure.
Thank you.
Bye bye.
We really enjoyed your
Thank you.
provocative presentation. Thank you so much.
Stefano, I guess there were two questions for Professor Madame Hongiao by Elisa Baroncini.
Oh yes. Elisa, maybe you want to recall the questions?
Question about
Look at new generation free trade.
You know, that was my question. She made two questions at the very beginning, but then probably Matthias step in. Elisa, if you are still online.
Elisa, I think you are there. So if you want to
Well,
step in.
Yes,
Okay.
I step in. Basically, I was asking to Professor Hong what she thinks about the future possible use of the MPIA by the MPIA parties due to the fact that we don't have at the horizon appearing a significant shared reform process of the dispute settlement mechanism. So whether the MPIA parties will make a greater use of the MPIA and whether the non-PIA parties will be inspired by this interim mechanism to settle the dispute at a sort of appellate stage. So what is your opinion?
Oh, thanks very much for that question. I thought it's very a good question to respond. Actually, Marcos, who is a Brazilian lawyer, who participated the seminars of March 6, which I organized in PKU Law School. He raised the same question that what is the way to bring the United States back to a binding dispute settlement mechanism at World Trade Organization. And my approach, my answer to that question of him, at the end of the meeting is that I said, let's play, make a fair play at the MPIA. Make the MPIA, which is still alive, a good example of dispute settlement. To let the system without the participation of U.S., a big member, to be successful, because we want the system to be good, to be fair to every member, to have a due process, to have its own, integrities of its decisions, and setting up examples for all members, and that make that system more attractive. And that also set up, I think, be helpful in setting up confidences of members in dispute settlement. That is my answer to him. And I think, to me, for any international dispute settlement at any level, regional, plurilateral, or the multilateral, it is for the, it is for justice. It's for the fair result. To apply the law of that treaty correctly, to interpret the treaty in good faith, and to make a fair decision for all parties. When the party come into before a court or a judicial body, they want to have a fair outcome. They want the rules to be played fairly. They want to have a trust of the organization. But then the organization needs to establish its own credibility by each of its interpretations and each of its decisions. That is the fair play of the system that bring back people back and bring the confidence, setting up the confidence of all participants to that process. There's nothing else, I think. So that's my answer to these questions. And I do believe all the former members of appellate body, I think they hold closely the integrity and the independence and impartiality at their heart and in every of the cases. And the composition of the representative of different regions of the world in that appellate body is in itself a check and balances for making sure that decision could be more or less fair and justiciable to the participants. I think that is the reason still the most majority of members trust and like to support the appellate body. But that members decide what would be the outcome. But recently I have a sense that quite it may not be so fair for telling the overreaching or the quite some number of concerns. The appellate body make 130 decisions, but you cannot focus on a few of them and a few matters. So roughly over the past 25 years, the appellate body did make good decisions, and they help members settle their dispute to the great extent. And I think, of course, there are groans and misgivings, and here and there, even China has its own, complaints. The EU and the US, they all have different, complaints on some of the cases. But overall, in general, I think appellate body and the World Trade Organization dispute settlement mechanism over the past 25 years did, I think, somehow did a fair job, and that could be witnessed by everyone. That is why the system still operates, though the appellate body is in limbo. But we hope member could resolve that matter. And next year would be the 30th anniversary of the World Trade Organization. Let's see what's going to happen at the end of the year, and hope that we will bring back reactivated the operation of the appellate body or the review body at the second stage. Thank you. I hope that helped you.
A big thank you, Professor Ong. Very, very thoughtful and thought-provoking. Thank you so much.
Okay, so at this point, I take back my role of moderator. Stefano, are there any other questions pending?
I don't see so. I don't see anything unanswered.
So I thank the participants, especially Zhao and Mitsuo for it's already late today. And Leonardo will organize a second part at 2:30 European Central Time. And I say goodbye to everybody in the meantime. Leonardo, anything to it?
No, we are joining at 2:15 for those who are interested, because we try to start a little bit earlier in order to be perfectly on time, because some of the speakers have time constraints. So 2:15 for those.
And I think Leonardo will be the moderator in the afternoon, right?
Sure.
Yes, no problem at all. I will be there. Thank you very much.
Okay, bye-bye. Thank you.
Okay, bye.
Thank you,
See you
Zhao.
later.
Nice to see you. Bye.
Thank you. Thank you.